All right, everyone, I'm back, and I cannot wait to introduce you to my guest today. Introducing you to my friend and yours, Mr. Brett Barkman.
Hey Ben, how's it going today?
Hey, Brett, thanks for coming on the show. I really appreciate it.
Oh, it's a pleasure, always.
So, what are we talking about today?
So today I had a couple of topics, but I was thinking first and foremost, the big one, income inequality and legal process.
So, for those of you who are watching, this is going to be a pretty deep dive. We're going to do our best. So, both of us went to law school. We're both attorneys. So, just so you know, we are going to speak a little bit of legalese, but we will do our best to translate. If you have questions about anything we say today, or you want to look up anything that we're talking about today, leave a comment below, and I will pass all of the information, all of your questions to Brett, or I will look them up myself, and I'll provide an answer to every little thing that we do here today where there are questions. So, Brett, take it away.
Of course. So Ben, as you and I both know, one of the fundamental things in the criminal process is that you have a right to an attorney. However, civilly, this is not the case. Now,
So why don't you explain what a civil case is real quick for people who might not know?
my apologies. So, in a criminal case, the state is usually bringing an action against an individual. In a civil case, a person can bring an action against another person or other entity. It doesn't necessarily have to be the state.
Think about it this way. When you're watching Judge Judy, that's a civil case. When you're watching SVU, that's a criminal case.
Exactly. One thing that this actually brings up, though, is the issue of what is the importance of being represented in a civil case? As we all know, in a criminal case, the importance is you want your rights protected. And people don't always know the depths of any given right, the exceptions to that right, and anything in between. In a civil case, however, those rights aren't necessarily guaranteed because an expert or a legal representative isn't necessarily an entitlement that you have.
So before we proceed, why don't you tell people what rights they do have and where those rights come from? I think it's helpful for people who haven't gone to law school to have a general understanding about, like, when you're involved in a criminal proceeding, what rights do you have as a defendant, as in someone who's been accused of a crime, and where those rights come from.
Of course. So in this case, we're talking about the Constitution. That is going to set your ground floor for all of the rights that you have in a legal proceeding. Now, the one we're specifically talking about implicates the Fifth and the Sixth Amendments. These guarantee you the right to an attorney, as well as the work done between you and the attorney, conversations you have, and the work product they make.
So the work product of an attorney is anything that goes down on paper that your attorney submits to the judge on your behalf, like motions, pleadings, and the like.
Another important one, legal strategy, which goes more into the civil issue that we're talking about. As some people might know, you don't, and as we've said probably 3 times already, you don't have the right to an attorney in a civil proceeding. The problem with that is when you're bringing a case, you may not be able to afford to have an expert there by your side telling you what you're allowed to do.
And this is really important, especially because in a civil case, typically you're suing someone or being sued because you have been harmed or have harmed someone else. So the problem, one of the problems that we're going to talk about is how people are unable to resolve the harm that has been caused to them or by them because they don't have an expert there to help them.
Exactly. One of the biggest problems that this is implicated in is in property right law. So, Ben, say you have a house. Say I'm infringing on the right to live there, or infringing on your right to quiet enjoyment by living.
You should explain what quiet enjoyment is.
Getting ahead of myself. My bad, everybody. So, quiet enjoyment is your ability to enjoy the property that you either A, are leasing from a landlord, and that lease gives you the power to enjoy and utilize the property as if it were your own during the period that that lease is enacted, or B, the property that you own outright and have full use of. Now, in this case, let's say someone else were to come into that property that you never gave permission. They want to use a piece of the land. It could be for personal use, could be to live there, anything really. But you don't want them to use it. You pay for it. Why should I have to share it? Exactly. So.
Oh, go ahead.
Oh, my apologies.
No, continue. Sorry.
So anyway, what do? You might not know what to do or how to even stop the process. So to begin, you would want to encounter, or you would want to actually meet with an attorney. Just a heads up to anybody that might be in any problems at the moment. Most attorneys will actually do one meeting for free and help get you at least a little guidance, or maybe even say if you have a case at all.
So during this meeting, typically what an attorney will tell you is how much it's going to cost to use them and whether the lawyer thinks you have a chance at winning. When Brett says whether you have a case, essentially you go to a lawyer and you say, hey, I have this problem. Bob from down the block decided to build a chicken coop on my land, and I did not tell Bob he could do that. So you want to evict the chicken coop that Bob built on your land from your land, right? It's just hypothetical. But you then go to an attorney, because you're not a lawyer yourself, in theory, and the attorney tells you whether or not you are actually able to take that case into a courtroom and have a judge resolve the case in your favor. Essentially, not only are they saying if you can win, but they're also telling you how it is you might win.
And just as another resource I wanted to mention before we continue, there is also programs, pro bono opportunities that people could look into in case you fall under a low income, in which case you might actually have access to certain attorneys in civil issues.
So just a quick clarification, pro bono is a set of Latin words that describes when a lawyer does work for free for people who cannot usually afford their services. Don't worry about the Latin translation. Neither of us learned it. It's really not a big deal. Essentially, if you're asking someone to do something for you pro bono, it means bo free.
Yeah. And also, if anyone ever just starts throwing Latin around, they're trying to be extra fancy. Don't sweat it. Now, sorry, what were the topic we were just about?
So in this point, you've gone to your attorney and you've asked them some questions, and we're figuring out whether or not you can get anywhere in the first place. Remember, we're in a civil case. So what happens now?
So now comes a big problem. Bob, having this chicken coop, is a real jerk because he put it on your land. But let's say Bob has, I don't know, dozens of chicken coops and they're very profitable. Bob has an attorney named, let's say John, for instance. John's very good at what he does, and John knows his stuff. He's been working in this field for, let's say, 10 years, and he knows the process inside out. Not only does he know it, he's got templates for the paperwork, and he can pretty much get stuff knocked out in a day or so if he really wanted to put in the grind.
So what all this means effectively is, so in the case that we're discussing, Bob, who's put the chicken coop on your land, has a lot of money to pay a good attorney to do his job really well, which puts you at a significant disadvantage, which we're talking a little bit about. So what the question kind of becomes what can you do if you don't have money for an attorney and you don't qualify for a program? Like, what does it look like? Why are you disadvantaged? Talk a little bit about that.
Of course, and honestly, a bit of the proof is in the pudding. Think about how me and Ben are going on this back and forth. I'm just kind of putting out the information that I'm aware of, and Ben's kind of filtering it for people that don't understand perhaps what's referred to as legalese. In that case, people might not even understand what's being spoken about in a court proceeding, much less, things like petitions, where people actually try and get something started so that they could get to a court proceeding. Another individual issue is actually knowing where to get petitions. How do you make one? Do you know how to fill out all the information you need? These are all such fundamental concepts that the individual might not even be able to get the ball rolling, much less get to a case.
And additionally, a judge is not there to help you. The judge is meant essentially as a referee. So in the American legal system, you are competing against the person on the other side of what lawyers call the V, as in your name versus their name. So you're competing with them to prove your case to a judge, and sometimes a jury, but in civil cases, oftentimes you're doing it before a judge. So what happens is, if you can't participate in the legal process because you just don't know how it works, and the counterparty, your opponent, knows how the process works, they're going to be able to essentially either trick you or to confuse you into potentially losing somewhere where you were harmed. Remember, in this case, Bob built his chicken coop on land that you already own. That's not right. You've been harmed. The legal system would agree that you're harmed. But the problem becomes, if you can't afford an attorney, then
you fall under the issue of not even being able to understand what your full rights are and the extent that you can enforce them. This basically makes it so that you have to have a certain level of payment go out to even enforce rights that you inherently have when you bought the land. This becomes a problem because obviously you have a right. It's not supposed to be, oh, if you add in this extra money, then you can enforce that right. It's a right. You have it at the onset.
So why don't we talk a little bit about how expensive it is and where. So we're talking about little bits of money, but we don't really mean like a little bit of money. It's more like a little bit here, a little bit there. Can you talk our viewers through like how much it costs to go to court and why you need to essentially why you need money at all in this process? Where's the money going? What are you paying for? Things like that.
Of course. So one of the first steps in a civil case is filing what's called a complaint. This, as the name suggests, is where you complain about someone else that has done something that has caused you damages or mitigated your fair use of something.
So damages typically is a harm that's inflicted on you that would cost them money to repair to you. Depriving you of your fair use of something might mean that they stole something or they trespassed on your land or anything else where it can be rectified by the individual stopping doing the thing they're doing. So in this case, Bob wouldn't have to pay you for the land to take the chicken coop off, right? Bob would just have to move the damn chicken coop, right? And then you would be what's called whole. You would be made whole, which is the legal system's way of saying we've resolved your problem.
Yep. And the problem with that becomes, though, even drafting a complaint, getting it ready, and making all the facts known can cost, depending on the quality of the attorney, anywhere from $200 an hour to $300 an hour. Now, let's say you're making the.
Well, let's not go down that road. People will know how much what it will cost them. So if you have to file this on your own, if you have to file this on your own, you don't have an attorney. Talk about the cost of just trying to do this on your own. Let's leave an attorney out of it for a second. Bob has a great attorney. John's got it covered. We're on our own. What fees do we have to pay to just tell a judge that we've got a problem and get them to try and solve it?
Yeah, so even just to start out, it can cost over $50 just to file a complaint. This doesn't mean you're guaranteed anything. This doesn't mean that you have your rights being enforced. All it means is that you made a docket, that you've gotten the issue known to the state, and that they have to actually respond to that complaint within a certain period.
So a docket is essentially a judge's workload. So essentially, you get what's called a case number, which is essentially just, imagine you're at the deli, right? You pull one of those tabs. Essentially, your case number is that little tab you pulled, and you paid $50 to get that little tab. That's just the first step. In this allegory, you haven't even ordered anything yet, right? You haven't even put in anything. You just told the deli essentially that, hey, I have a number, call me at some point.
Yeah, and then the issue stems that they can answer. Obviously, you would hope they don't answer, and you immediately get what you want because no one ever responded. Unfortunately, in this case with Bob, that chicken coop's making money. He doesn't want to back down, so he answers you. Now you have to follow up. This is going to cost another additional fee because now you have to put an additional document and or petition on the docket that we mentioned. Unfortunately, this can be, well, I'm sorry, let me back up because I'm jumping ahead of myself. When they answer, they're going to have to let you know. Now, not only do you not have an expert letting you know, like, you have this time period to do this, you have this time period to do this, you're on your own. So you have to know not only how to figure out what you're doing, you have to figure it out pretty quickly. You have about, depending on the issue and depending on how quick the judge will go, 90 to 120 days usually to respond.
Right. And so this sounds like a lot of time, but in reality, this is one of the faster stages of going to court. So if you don't know what you're doing and you're trying to spend all this time to secure meetings with people to try and figure out what it is, 90 days can actually feel like a very short amount of time. And by the way, once you receive the answer, there's money involved here too. So there's an additional step. Can you explain kind of what it's going to cost people or how fees are involved in just getting past this answer stage? And by the way, tell people how early in the process we're still talking. Like we've barely gotten anywhere, right?
Oh, yeah. To be honest, I could talk for days about the entirety of the process. We're literally, by saying answer, step 2. We've only gotten to 2 steps, so we haven't even made it anywhere really at this point.
Yeah, so let's try and focus our conversation on where the fees come in and why and why it is that there hasn't been anything to address the fact that these fees add up, right? So talk a little bit about what it all costs, and then talk a little bit about what's going on with it in the sense of how it creates inequalities and how it hurts people.
Of course. So let's say hypothetically that you know that Bob's gotten this attorney. Now you feel the need to get one yourself. One of the key issues in this is you've got your own life to go. You don't have the time to necessarily learn the law, know the rules, and know how to draft these documents. Now, by getting this person, as I mentioned before, they could cost up to $200, sometimes even $300 an hour. Let's say they take hour and a half to do the initial complaint. You're out about $300 to $400 roughly. That, for a lot of people, is a fairly large sum. And as we said, we haven't even really gotten anywhere yet. That's just the first step. Now, Bob has way more money than you. For him, that 90 minutes might not be nothing. Could be just a day's pay for him. Who knows? But in this case, for a lot of people, we suffer days at a time. Now, every time they file something in response to yours, you're going to have an extra charge. And not only that, it's not only a response, communications, drafting a strategy, meeting with the person that you're trying to learn from, and understanding what your position is in the current issue. These are all things that eventually add up. You think that you might just be going to chat for 15 minutes to be told you're okay or you're in the rough. It might lead to an hour explanation as to why you need to focus on documenting how he's using the land. How big is the chicken coop? To what extent is there damage to the actual property itself? These things add up over time while Bob is still sitting comfortably because this is just another day for him and a part of the business. For you, it's an infringement on your right to use land.
Yeah, absolutely. So you can see that as these things can really add up. So this actually piggybacks on something that I talked about a couple weeks ago called corporate lawfare. So lawfare is essentially, I'll remind the audience, is the practice of using the legal system to impose unnecessary costs on opposite parties in order to essentially to force them to give up their fight because they just can't afford to do it anymore. So essentially, parties with more money can afford to create frivolous, which is just kind of legalese for nonsense or unnecessary or superfluous documents and document requests, all of which cost you money. So even if you've been harmed, the person on the other side, the person you're suing, might be able to avoid dealing with your harm at all just by forcing you to go bankrupt by trying to prosecute this case for something that, as we mentioned earlier, should be your right. You shouldn't have to. It shouldn't have to cost you anything to exercise your use of your land or your home or whatever it is.
Exactly. I believe the layperson term was the Walmart defense. This was something used by Walmart when it moved into small towns, and other businesses would actually bring suits against Walmart for their business practices in those towns. Unfortunately, Walmart, being the vast corporation that it is, has the funds and a team of lawyers at the ready in order to fight those battles. The small town with a small shop that's owned by mom and pop, they don't have these resources and they can't stand up to the fight too long. They're usually out before the battle even really begins, unfortunately.
Yeah, so why don't you go back to talking about like what the steps are, and then just as we talk about each step of the process, so just kind of minimalistic process. So talk about each step of the process, and then talk about kind of where fees come in at each stage.
Sure. So, as we already said, to initiate, you have a complaint, and then you have an answer. This answer could also bring in a new matter, in which case you, as the landowner, in our hypothetical with the chicken coop, would have to respond to again. And
so a new matter, by the way, for the audience, is essentially where someone in the case essentially brings up something else. They're like, hey, look, you're suing me. Maybe they want to countersue, or maybe they had another issue with you that they weren't going to bring up, but now that you've got them in court, they want to bring it up anyway, right? So think about it as being a grudge or something that's kind of attached to the case. It doesn't have to be that related. Essentially, you can go into this with the idea that you're in court for one thing, But because they have you in court, they might sue you for something completely different. And because it's all occurring at the same time, oftentimes these will be decided at the same time.
Exactly. The other issue with that is, even after just having a response, if they have a new matter, you have to start going on the defensive. This means, once again, having to meet up and then doing legal research, possibly taking time out of your day. And if you have the ability to afford legal representation, putting in those fees as well. After this, we typically have issues about things like jurisdiction. If Bob has the opportunity to say, you can't fight me in court X, only in court Y, the state over, you have to fight that battle before you're even really able to get to your key issue.
Yeah, so jurisdiction essentially is a grouping of laws that says this court can hear cases about these things in this particular area. So when decisions are being made about this, and by the way, all of these conversations that you're essentially having with the court cost you money, right? Every time you initiate a conversation or you respond back to the court, you respond back to your opponent, you have to file documentation with the court, and fees come in. Okay, so let's move on to the next stage. So we've gotten here in complaint and answer. We have a jurisdiction discussion. We've discussed how money comes in. What's the next stage of litigation, and how does money come in there?
Okay, so let's say that you get past the actual filing document stage. Now you're starting to look to actually having something before the judge. Now, there is a thing called a list for a judge. Any given day, they might have only one item, could be a couple items, might be a dozen items. Who knows, really? It just depends on the individual judge and how they plan their schedule. During this time, your attorney is going to have to be present and available, because who knows? Maybe you're the first item on that list. Maybe you're the third, but the first two go by like that.
So a list is a queue, right? So essentially, think about it, your job, right? You have a list of things you have to get done every day, or customers in line, right? If you work in a place where customers can queue up, right? So essentially, there's a line of people who want their issues resolved, and you will be put on the line somewhere, but you only find out where you're put on the line when you arrive. So if you are paying for attorney, your attorney has to be there, maybe even all day, and you have to pay for all of that, because at any given moment, your number could get called.
Exactly. And then, to top it all off, you might not even be able to have your whole issue heard that day. There's terms like bifurcation, where you might hear one issue of the total concern, and then maybe 2 weeks later, 30 days later, they have you in again in order to hear the second part, and this could be broken into 3, 4 more complicated issues if they have responses to other issues during that same nucleus of fact. I apologize.
Explain that. Yeah.
Will do. By nucleus of fact, I mean the same fact pattern from which the issue arose. Say that we talk about the land with Bob having a chicken coop in it. Say that a bunch of his chickens get sick from well water on the property, hypothetically. Now you're not only trying to say that Bob can't use your land, you have to fight it off and say that you shouldn't have to pay for any damages to replace the chickens that got sick and could no longer lay eggs.
Yeah, so, all right, so we're here. We've gotten to the part where we're filing, you're on the list. So say you get all this way, and you pay all the fees, you can afford all of it. What's next? What happens after this?
So the ideal would be that you'd be able to get to a final decision as quickly as possible.
So what's a final decision? And who makes a final decision?
Yeah, I probably should back it up a little bit. My apologies.
You're good.
The judge is the one that makes the final decision. Obviously, if you have a jury trial, they get to make the actual final decision, while the judge gets to actually just oversee the courtroom and acts as an unbiased third party. At this point, the judge will usually say that they have to take in consideration all testimony, which is when you bring up people to actually speak about issues and see if, well, one, if they're credible, meaning that the court actually finds them to be speaking the truth and not being deceitful in any way, and if so, to what extent. Any documentation that's provided, that could be anything like video, photographs, affidavits, things of that nature.
Explain an affidavit.
Always jumping the gun. I apologize. Affidavit is a statement by an individual that could be either your attorney saying that something's true as an officer of the court, or by an individual that would usually sign off on something as to what's known as 4904, I believe it is.
It'll differ per state, so don't use numbers.
Oh, sorry. A rule that states that you are swearing basically under oath, essentially, that the statements made and are written in the document are true. You sign off on it, and it's basically as good as legally saying that this is the God's honest truth.
So think in our Bob example, the witnesses you might need are a surveyor or someone who tells people where their property ends. That person might be a witness. Maybe your neighbor saw the chicken coop get built on your land. There's a witness, right? So these are all people who can help in your case. By the way, Bob's going to have his own witnesses and documents too, but let's just talk about the example where you are fighting Bob, right? So you might want a surveyor to talk. You might want their neighbor or spouse to talk, and they could give testimony. Maybe you have pictures of the chicken coop on your land. Maybe you have maybe the surveyor provided a document saying your land goes so far, and they can show with a photograph that the chicken coop is on that land. And an affidavit might be the surveyor saying, hey, while I was surveying the land, I swear that I saw the chicken coop in the area that I marked as your land, right? So just to give you a sense, like for our example, what this kind of looks like. And by the way, each time you submit one of these, it costs you money.
Yeah. And to go back to the hourly rates, if you have somebody testifying, let's say you have a neighbor to your left, to your right, and behind you, and you want all three to testify. It's not unheard of for a testimony to be an hour long each. Now you're at 3 hours, and you haven't even really gotten to the meat of the issue. You're just trying to get out the exposition that helps build the foundation of your case.
Yeah. So let's go back to final decisions for a second, because we didn't really get to that. So final decision, tell me about the final decision. Who makes it? What does the final decision look like? Does it cost you money?
So thankfully, the final decision isn't actually that big of a deal when you have to deal with that.
Sure.
The judge is going to make a final decision and give an order or a decree, and that will actually lay out all the details as to who wins, to what extent, and whatever damages might have to be paid off to the other person.
Also, why they won.
Well, exactly.
Yeah,
yes.
why they won too. Okay, yeah.
They will have to give you things like rules within your state that actually apply in your current issue, how they're interpreted based on precedents. Precedents in this case being your previous case law, previous opinions that are given on similar topics or similar questions of law.
So once you're at this stage, say you lose because Bob used his fancy schmancy John attorney to outwit you. Do you have any recourse? What can you do now?
You are able to appeal.
Does an appeal cost money?
Oh, yes, it does.
All right, talk to me
Quite
about
a lot.
talk to me about an appeal, the stages an appeal, and what their cost money. Because so the reason I keep asking Brett this is I want to get all the way through this whole process, and then I want to talk, and then I want our conversation to transition to the inequalities, what can be done about it, and why things aren't being done about it. I want to get to a more substantive conversation, but I want to lay the groundwork, the factual foundation first for the point that we want to make later, which is kind of how it's so unfair. But so talk me through an appeal and then talk me through the money process.
Sure. So in order to have an appeal, first off, you have to have some valid reason to even do so.
What counts as a valid reason, Brett?
This could be that maybe there was evidence that should have been allowed in, but you couldn't argue the right reasons why it should be. And maybe that fancy schmancy lawyer was just able to say, objection, Your Honor, we don't believe that this should be allowed for reasons X, Y, Z. Now, in this hypothetical, the evidence was very valid, and maybe the judge just needed you to say something and you weren't able because you lacked the knowledge in this area. So there was no reason to sustain or overrule his objection, my apologies, and the evidence gets excluded. Now you're up Schitt's Creek and you're trying to figure out what to do.
So quick pause here. So we were talking about evidence before in terms of testimonies and witness statements and affidavits and documents. So these are all evidence, and a judge essentially decides what gets to count towards the end result, right? So it's called exclusion of evidence. So think of it this way. The judge is acting as a filter. So all the evidence from all the parties goes in this big sieve called judge. And at the other end of it, at the other end of the funnel, is what is called allowable evidence or legal evidence. And that makes up what is actually used to make a decision about the case. So if you think about it, if you had a piece of evidence that you thought really helped you prove that Bob's a jackass and built a coop on your yard, and the judge said, well, it doesn't really fit, or it's not relevant, or used some other reason to exclude it, and that would have really made your case, that might be a reason for an appeal. That's what Brett's saying. So what are the valid reasons?
Another would be that you believe that their interpretation of the law or the outcome was just blatantly wrong. That maybe you think that, oh, the way they interpreted the law isn't how it actually should be interpreted. I want to appeal this decision and say that it has to be kicked back for another do-over or for a do-over. This also doesn't necessarily get you in front of a new court, but it does get you put back in the court you were at to start with. Now, with the ability to actually bring forward either that piece of evidence or with a new interpretation of law in mind.
So we've gotten to the point where you can actually file the appeal. Does filing an appeal cost money?
Yes.
Does it cost a lot of money?
Quite a lot.
Okay, so say you have the money to file an appeal. Okay, so we've blown our life savings on the first trial, and we're filing an appeal. So once you're in appellate court, once you get your appeal through, then what happens, and does it cost money?
Well, then you can go in front of the appellate court, make these arguments like we've been talking about, saying that evidence should have been used for XYZ reasons, and those reasons are allowed by the law. The appellate court will say, oh, well, you're right. The lower court was wrong for what it did. We're going to send you back down. They're going to allow that in, and we're going to see if it makes a difference in the outcome. Or they could say, oh, sorry, buddy, you're SOL. Shouldn't have lost all that money, I guess.
Right. So, by the way, if you do get to have a new trial, it's a new trial. You're starting this process all over again. New fees, new documents, new court dates, right? This whole thing that you just spent all this money on, you got to do it again, right? Mm-hmm. There's no getting around that.
Oh, no, yeah. Once you pay the court, that money's gone. The court uses that in order to do administration, paying court officers and workers, basically making sure that the system can maintain itself.
Okay, so we've gotten through this process, and let's just say for simplicity's sake that you get all the way through the process, you go through it a second time, and you're able to win. So, and by the way, this hypothetical win situation, when you're doing this on your own without attorney, we're giving you like a huge benefit of the doubt. Like people who go it solo, who go without an attorney, it's called pro se in the legal world, but just it's going solo. Yeah. If you go solo through the court, I mean, you're fucked oftentimes, especially if your opponent has a lawyer. Now, in small claims court, like your Judge Judy types, sometimes no one has an attorney, and essentially you're just kind of the judge is asking questions, and they're trying to get to the law. But if it's a big deal, right? Say it's a really big chicken coop, and it's going to cost lots of money to remove, and there's lots of money involved. You actually have to go to a larger, more formalized court where all these processes come in. So it's not every legal case that's going to involve all these processes, right? If you go to a small claims court, sometimes you can do it alone. But if you have a big dispute where your rights are really being infringed upon, you have to go through a court and through all these things. So now we've kind of talked about the process. We've established there's a ton of money. And we're not talking hundreds of dollars. I mean, we were talking hundreds of dollars for just kind of the getting in the door. I mean, we're talking thousands of dollars. I mean, a court case from start to finish could cost you $10,000. And I don't know about you, but I don't have just $10,000 lying around for a court case. And yeah, right? Like, please, rain $10,000 bills on you from the sky. That $1 trillion coin, Joe Biden. Come on, give me the $1 trillion coin.
At this point, I'm just waiting on student loans to get forgiven.
Yeah, right. Actually, yeah. Fuck that. Cancel student loans first, okay? But then $1 trillion coin. One for me, one for thee, okay? And one for all y'all. Don't worry about it. We're all friends here. So,
and I'm sorry. There is one thing. It's a very important issue. And we are trying to tackle quite a lot in a small time frame. So there is going to be a lot that, unfortunately, might not get addressed. One thing I do want to say is, rather than just a rate basis, some attorneys will do it on a if you win, I get a certain percentage. And this is also a large percentage. Sometimes people misunderstand and think 10% is a norm or something like that. I do want to go and say that, especially in more difficult cases, you could be looking at 40% off the top of your winnings going right into your attorney's pocket. That's not even including anything with costs.
Yeah.
Anything that they might have to, you have costs for travel, you could have costs for doing depositions. If you need to get an expert to testify, should it be more complicated than a chicken coop in your yard?
By the way, a surveyor counts as an expert.
Yeah, that is true.
So
that expert's going to be charging you thousands as well. Experts don't come cheap, and that's why they're experts in part.
Yeah. Oh, the other thing about expertise is the court. So anytime you bring in an expert, you can't just bring in your friend Joe who happens to be a surveyor on the side. Like the court has to believe, like the court has to essentially evaluate that person's credentials and say, hey, you actually get to be a surveyor for the purpose of this case, even if they do it like in real life. So we've established kind of what the cost centers are. So something like this could cause a lot of harm to people who are poor.
Oh, clearly. If you're struggling to make ends meet, there is no way you can actually go and fight a battle in court. This leads to the concept that your civil rights, the things that you might be entitled to, aren't actually rights because you can't enforce it. You lack the money to enforce a right that you should have invested in you. And that, as you can imagine, becomes a big problem.
Yeah, and the thing is too, and this, by the way, we're talking about land because it's kind of the easiest thing to envision. But like, say someone is like, say you gave someone your house key, right? Like you were concerned that, hey, your cat needs to be looked after every now and again. So you give a trusted friend a house key. Say they lose it just for whatever reason, right? Or whatever. And you need to change the locks. And that's going to cost you a bunch of money. In order to get your friend to help you out and look, they're going to ghost you as soon as it costs them money. You know what I mean?
Yeah.
But like all these things cost money, and you end up in a situation where you have to go in front of a court. You have to get these fees done, and you should just like it should be easy to resolve these little things, right? And it becomes very difficult. It becomes these really long processes. The other thing that's difficult about this too is not only does it cost a lot of money, but it also takes a lot of time. So so Bob can drag this case out for years, right? So a standard civil case, we're looking at like a year or two, just your normal average case. So in this situation we were talking about with Bob, where you went to appeal and came back, this could be a 5-year process, a 4 or 5 year process. And in that time, Bob takes it down on his own because he's just made all the money he needs to make, right? But essentially, you can get totally used and abused in this time period because it takes so long and costs so much money.
And it's really a shame. Learning as we have about the legal field, it's about people being able to be people, really.
Yeah.
Enjoying their homes, not fearing their possessions being taken or destroyed. Things that are just so basic and fundamental that we kind of take it for granted a lot of the time.
Yeah.
Until eventually someone infringes on those rights, and you're just sitting there like, oh, I'm SOL. I can't afford to start a process in order to restitute or to get restitution.
Which is essentially payback for something that's rightfully yours.
Yeah. Another fancy word you can use is indemnify.
That means something a little different, but we'll not get there. So just to kind of wrap this up, because I want to move to our other topic.
Mm-hmm.
So I always like to end these pieces on kind of on a happy note. So we've talked a lot about like what a court process is, what it looks like, where the money is, like how much it costs, why it's unfair. So are there any people out there trying to rectify this injustice? Who are they? What do they do? Who pays them? Talk to me a little bit. I want to give some hope to people who are in real trouble. Like, are there organizations that exist in cities that you can call that might be able to help you if you don't have money for an attorney? Talk me through a little bit of this.
Sure. So one I can at least recommend within the Philadelphia area is called CLS, Community Legal Services. If you make below, I believe it is the bottom 20% mark below the poverty level,
you call them to find out if you qualify.
Yeah, always make sure. You can reach out to them, and they can help with issues like landlord-tenant law, possession issues, a wide variety, really. They don't have just one field, and they have a ton of help and support as a nonprofit. Another thing I would recommend
Does CLS cost you money?
No. As I said, they are nonprofits, so they will help out people that are less fortunate, and it won't cost them anything. One other group, you can look for pro bono opportunities. There are tons of programs in the city where people on various topics will help free of charge because they just believe in the charity of giving.
Also, and maybe they don't believe in the charity of giving. I'm going to be a little.
Well,
I'm going to be a little bit of a downer for this little bit. So, by the way, most attorneys are required to do 50 hours of pro bono work per year. So, hey, squeeze yourself in right on those 50 hours if you can. Now, it's not a rule; they don't have to, but they are encouraged to. So, pro bono is also great. Sorry, I cut you off. So,
I wanted to be optimistic. That was
all. Okay, so you can find a lawyer who will do a pro bono. You have community legal services and other similarly situated legal organizations. Mm-hmm. Is there anyone else? Are there are there practice groups? Do law firms do some of this work? Talk to me a little bit about what other landscape there is for if you're in trouble, can you get legal help?
So the truth of the matter is it really varies by county.
Mm-hmm.
So you're going to want to look and do a little research into what's nearby in your region. Honestly,
so if someone's Googling something, what should they look up, right? So people, if you're in trouble, you might not know what to look up for. So if you're Googling, you go to Google, what should you type in the search bar so that you might find one of these do-gooders?
Sure. So pro bono programs is usually a good method of searching. It'll bring up, as we mentioned before, pro bono opportunities, which are free services that attorneys are doing because they either really care and want to help people, or, as Ben said, they might need those 50 hours. Who knows? But you get to take advantage of it regardless. So if you are having trouble, always make sure to look for those programs. They can vary based on county to county, but they are super helpful.
Yeah, and so just the last thing on these. So for things like community legal services and for people who do pro bono work, different lawyers do different things, right? So when you're looking at pro bono programs or you're Googling the word pro bono, put in one or two words about the legal issue you're experiencing, and it will help you find someone. Also, organizations like LegalZoom or 1-800-MY-LAWYER or some of those may be able to help you, but a lot of the times, an organization like that, and by the way, you'll know those organizations because they typically put ads on Google. Yeah. And that's, by the way, because they can afford to do so. So they're not giving out lawyers for free. Oftentimes they're giving out lawyers for money, and lawyers have paid to be in that registry. Mm-hmm. So it's an important thing to remember. But if you are in legal trouble, regardless of what city you live in, go to Google, look for lawyers who will do free work, look for organizations similar to community legal services, or just look up legal services organizations in my county or legal service organizations near me. These will be able to help you, and they may not be able to help you with everything, but they may be able to point you in the right direction.
And I agree, yeah. These terms are always very helpful, specifically state to state. They might change, but with using a decent search engine, you can always usually find some program in your vicinity. And also, one thing to keep in mind, some of these programs operate in very specific time frames. One I did back in school was to help do expungements for people that were qualified.
What's an expungement, Brett?
That's a good question, Ben. An expungement is something when you have a criminal record and you want to get it removed for any given reason. Perhaps you're looking for a place to rent, maybe you're looking for work, maybe you want to do some volunteer work and they require a background check. Whatever it might be. The point of an expungement is to remove stuff that is either old and minor, just to take it off so you don't pop up on searches. And really to help people move on from past mistakes and try to improve themselves and work towards the future.
Yeah, because a crime shouldn't hold you back your whole life. It just shouldn't. So we have some time left. I want to talk about our second topic. So the second topic we were talking about was
falls right in after we were talking about expungements. So, Fourth Amendment and technology. The Fourth Amendment, as I think most people know, is your protection from search and seizure.
What's a seizure, Brett?
Almost should have gone back more. A seizure is when they basically take either your items or your person and prevent you from having what's called forward locomotion or bodily autonomy. Basically,
they hold you in place.
Yeah.
Or throw you in the slammer.
Hopefully not that part.
Yeah,
But yeah, we're
yeah.
going to start a little before that.
They hold you in place, right? So it essentially stops the cop from grabbing you.
Yeah, pretty much.
Yeah.
In this case, however, we're going to talk about how technology has affected that right. So one thing that was done that we talk about in law school as a basic thing in criminal law is how cars had a slew of case law, which just basically weakened the Fourth Amendment. This is because people actually were afraid of cars being so mobile. It started out in the 1800s after they became sort of more economically available to the public.
I'm pretty sure that the Model T Ford was 1905.
Well, okay. Well,
Yeah, it says 1900s. No
Well,
worries.
my expertise is not in cars. Okay.
or history. Yeah, all good. No, sorry. Go ahead. Cars.
Anywho, yes. Basically, the point is that this was a period where it was almost taboo to think that officers could lie or that they would be deceitful in any way. So everything was taken very strong to heart. The problem was that they were afraid of evidence apparently going missing or being taken, destroyed, flushed, what have you. So the courts basically allowed a loophole in the Fourth Amendment that says you don't have a privacy in a vehicle because exigency exists. I was, ahead of you on this one.
All right, very good. Hey, man, I'm just trying to help the audience. Sorry, go ahead. What is exigency? And then we're actually have to go back a little bit because I want to ask you something else. So go ahead.
I got you. So exigency is basically a fear of evidence, as I said, being destroyed, going missing, being hidden, in the knowing that, like, oh, the cops are coming, they're going to make efforts to get a warrant so they could actually legally search and seize my person and my items and what have you. And I'm sorry, you said that you wanted to go back a little bit.
Yeah, I want to go back a little bit. So talk to us about, because you went right into the cars thing, right? So before there were cars and a cop wanted to stop you and search you, what did they have to do?
Oh, they'd have to get a warrant. Basically, they would have to go to a judge and they would have to describe like the probable cause that they have. And to be honest, probable cause is a little hard to describe, but effectively, if an experienced officer can articulate valid reasons that would show that they believe a crime is in progress or will become or will be done upcoming, they could go to a judge, articulate those reasons. The judge says, all right, probable cause exists, give out a warrant, and the police can do a search and seizure.
So the reason this step exists in the first place is essentially there was a concern at the founding of the country that as soon as we had cops, they would just start like taking people's stuff and arresting them for no goddamn reason. So the point of having the step in was to say, hey, if you're an officer of the law, it would have been constable instead of cop back then, but if you were a constable, you had to go in front of a judge and say, hey, I think this person is going to commit a crime. Here's why I think they're going to commit a crime. Here's what I saw, and then they have to pass it off to the judge. And by the way, they have to swear that that's all true. Now, unfortunately, in modern times, never mind. Anyway, it's not as clean anymore. But so before cars, right, before this kind of started getting whittled away, the constable has to go in front of the judge and say, hey, I swear all these things. I believe all these things. Will you allow me to kind of hold this person in place to prevent them from doing crime? And the judge says, sure, Jimmy, you got it. So they hand them a piece of paper called a warrant, and that's what Brett was talking about there. That's the probable cause, that kind of explanation of things.
Yeah.
So that's pre-car, right? And it goes like this for a while. So why are cars different? Not just because they have wheels and they're mobile, but like what about a car other than its mobility?
Well, to be honest, the mobility was one of the biggest fears.
Right, but I know that. So what I'm trying to tease out here is what can you put in a car that you can't carry on your person, right?
So drugs, firearms, these were the things that were considered the biggest concerns.
All of which could be hidden in a vehicle in theory.
Yeah. Of course, there are certain exceptions to the exception because why can't the law be more complicated? So if you do have anything that would be perhaps locked with a key or sealed like an envelope, you might have an argument to an exception where they can't break these locks or seals in order to get to a box or something else, some sort of container. They actually would need to take that from the car, get a warrant, and then could get into that box itself, and then try to find whatever you might be hiding. quote unquote.
So a box like the trunk of a car, maybe.
That is one, and
Okay,
that's the
so-
most notorious.
Yeah. So let's talk about it. And we're gonna get to more technological stuff later, but let's just talk through the car example here. Let's talk through cars. So obviously, a car can drive away, right? While a cop is going to a judge and getting this document, right? So, and the other thing that you can do with a car is you can lock components of the car, right? So talk through the trunk problem, and then talk through what happened. How did cops get their way at the end?
Yeah, so unfortunately, as we all know, you can get pulled over and the cops can talk to you. They can keep you there for a time. This is because when you're using your car, as I mentioned, exigency issues with the containments of the car. So you get pulled over by a cop and now he's talking to you. You know, can I run your plates? Can I run your driver's license? Blah, 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 whatever. They want to basically be able to look in your car, in your back seat. Fun fact, that's why people have problem with tinted windows, because cops aren't able to easily see within the car's back seat, passenger side, and see what might be inside. And there's a fear that inherently having tinted windows is a sign of criminal activity.
That's so stupid. No, that's a great side note. Tint your car windows. Hey, Dad. All right. Anyway,
Well, by the legal amount. Or
Tint your windows to the extent legally permissible.
This varies state by state.
Yeah,
Anywho, I'm sorry.
By the way, if you want to tint your windows, this is just a random aside. If you do want to tint your windows, like if you go to a person who actually does it professionally, they'll know how much you're allowed to tint it. So don't worry about that. Anyway, so tinted windows, cars, take away.
Yeah. So one of the, in my personal opinion, the craziest levels that this kind of escalated was a case where a man was basically being tailed by cops because they had pretext.
What's pretext, Brett?
For those that might not know, pretext is when cops say, I knew he had drugs or I knew he had a gun because reasons X, Y, Z. He's scary or something. But really deep down, they might have things like racial components, gender, sexuality, these kind of things that you're not allowed to obviously use as a reason to arrest someone. However, they don't need to state those with specificity. They just have to find some way to subjugate that. So
this is where so if you hear on your local news station that the car smelled like weed, this is one of those I'm pulling over a black person, but not because they're black excuses, right? Like it's essentially, it's like, oh, well, the car looked like weed or there was white powder somewhere, right? Yeah. Whatever, they can say whatever they want because they don't have to prove it, right? This is kind of the problem with pretext, is that no one ever challenges them on it, which is really a problem.
Yeah, and that goes into what's called the plain sight rule. Basically, it's the rule that says when a cop sees something that's illegal contraband that a person does not have a privacy interest in, they immediately can search the vicinity and what's called the grab area. That means a certain radius around an individual in which they could quickly run, grab a thing, and maybe it's a weapon or that's the typical reason to prevent the officers from being hurt. However, I'm sorry.
No, I was just going to say that, like, so this is why the car smelled like weed thing is so insidious, because it's hard to prove, because obviously, like, weed aerosolizes, right, and then the smell's gone. But then once they say the car smelled like weed, they then have a justification to search the entire car, because the entire car, with some exceptions that you will get to, technically counts as the kind of plain sight, in this case, plain smell rule. So what are the exceptions to the rule?
So the exceptions would be, one, what I mentioned before, if it's locked up. So if you lock your trunk, they can't force you to unlock it. If you have...
Lock your glove box.
Also your glove box. That's a big one. Because even though you might have to pop it open to open it and see its contents, if you don't need a key, they can pop it open. That's the biggest thing beyond anything else. Another thing is, say you park your car after being tailed by police and exit the vehicle and lock the car itself. Should they find something on you, say a baggie of Coke in your shoe, not to say we I defended anyone like that or anything. But anyway, uh, they actually have the ability to look in the vehicle if they do find that you have illegal contraband and it's within a certain distance of the car. Obviously, if you're parking and you're half a mile away, that doesn't really work as well because they can't say that you got it from your vehicle. But if you're within, estimate guess like 25 feet roughly, something within the vicinity, they can actually get access to your car as a result of finding that illegal contraband, and they can search and seize things from that car as long as they also qualify. Things like, as we keep saying, firearms and drugs, the most common issues.
Sure. So essentially, rules were made. Rules were made because of the inherent nature of vehicles, this exigency that we talked about. So that was kind of the first major encroachment. So you wanted to talk more about modern technology. So talk to me about some of the modern technologies you're concerned about, why they're concerning, and what implications they have on your rights.
Yeah, so I wanted to talk a bit more on the digital age. Now, the car, obviously, for American culture, was a massive jump and has influenced us greatly. But now we're in the next section of that, computers. Now, what's the importance of that with the Fourth Amendment? One thing that everyone knows is you can just say to an officer, yeah, you could search my stuff. I don't care, whatever. I feel okay with that. But the flip side of that is you have the ability to say, actually, I take that back. I don't want you guys searching anymore. You're making me uncomfortable for whatever reason. That is your right. Just as you can give consent, you can retract it. Now, the problem is someone takes your computer. What are they really looking for? What is the point of taking a computer? It's the data. They don't care if you got an i7 processor or something really nice. No, they don't give a shit. The problem is all of that data easily copied. They can then take that copy and it's state property. So you might say, all right, here's my computer, and then like they take it maybe a day, maybe 12 hours, who knows really? Maybe it's only an hour and they were moving quick. And you say, actually, I feel uncomfortable. Can I have my stuff back? They give you the hardware, they give you the original, but they still possess that data. Now, this is an argument that goes a little above law and says how much of a person's own data and information do they actually own. We won't be talking on that as much, but only on maybe a small facet or two. In this case, the cops now have all that data. Do you have a privacy right in that data? I mean, I would personally believe so. I would hope so.
Yeah, right.
Unfortunately, courts did not. One of the cases was like the USB Megahead and USB Sharp. A couple of cases where cops took data and they made copies. People got their stuff back, but they didn't really own the data anymore because it was in the hands of the state. The state would then use it, research it, look into it, and go down the line and press charges, maybe make arrests.
Well, so let's stop there for just a second.
Mm-hmm.
So, a lot of the thing I hear from people who are kind of like pro kind of giant invasive police forces is, hey, if you're not doing anything wrong, like you got nothing to hide, right? So say you have that belief, right, and your data gets copied. Now, you think there's nothing nefarious in there. What if you really believe you've done nothing wrong? Then why wouldn't you want the state to have your data, Brett? No, but in all seriousness, why? What can they do with it that's dangerous to you, even if you think you've done nothing wrong?
So this is a part where we go into the property right of it.
Sure.
So obviously the Fourth Amendment's for privacy, but also for your property. One aspect of owning property is the right to destroy or get rid of stuff. There was, Giannis, I believe it was pronounced, USV Giannis, where a man had his information taken, they copied it, and 2 years later, based on accounting records, pressed charges against him, not based on the crime that they originally seized the data from, but on something else entirely. Now, 2 years is a long time. Let's be honest. I mean,
well, so that kind of brings it up. Do they ever have to destroy it?
Well,
are there any rules in place about if they'd have to destroy it?
In this minority jurisdiction, and by minority jurisdiction, I mean a very few court systems will actually do this rule. the majority would go against them, but the minority would say that they shouldn't have kept it that long. That his privacy interest and his right to destroy his property was invaded and infringed upon because they kept it for 2 years in hopes of being able to press charges against him later. And it's unfortunate because even today, like Facebook, for you old people like us, when they had MySpace, we had.
Wait, hang on. So is this the part where I have to admit I never had a MySpace?
Can I leave now? I feel like.
Oh no!
What
Okay,
happened?
hang on. I had an AIM. I had an AIM.
Okay, I'll give you a pass.
Okay, all right. I get to keep my millennial card.
There you go.
Okay, anyway. That
Yes.
aside.
Sorry,
Okay.
back to hand.
No, you're good. You're good. Okay. So Facebook. So why'd you bring up Facebook? Like, what does Facebook have to do with this?
Yeah, so say you wanted to get rid of old things. Maybe you made embarrassing, stupid, or ignorant posts.
Or
The
you wrote
idea
poems
is
as a teenager because you were depressed.
exactly.
I don't know anyone like that.
We can talk later.
Any-
It's okay.
Anyway,
But,
go on.
Anyway, the point is you have the right to get rid of these things. These past mistakes, negative influences you had. You have a right to destroy that data that's about you, that you created. In the legal issue, this man should have had the right over the course of 2 years to maybe clean up his act or get rid of this shit.
No.
He had that right infringed on because the police basically made a copy of everything, kept it, and then used that against him years later. And I mean, that's really the extent for the data with property because the state doesn't.
Yeah, so I wanted to. Sorry, so I wanted to ask that. So jurisdictions, states, and cities and stuff have statute of limitations. And just to give you a quick rundown, a statute of limitations says you can only pursue this legal issue for so long after it's occurred. So if you stole a car, don't do that. But if you stole a car, right, the state might say to the prosecutor, you've got 10 years to prosecute this crime. Because if you don't prosecute it within 10 years, then you can't be charged for it anymore. So for data that's stolen, and I'm going to call it stolen in this case, because I do feel like that's what's happening here. Do you have a substantive out here with statute of limitations?
So it follows the unfortunate answer that you get a lot of the time in the law. It depends. Because
just
there's
talk us through a little bit.
Sure. So as Ben said, in a lot of statute of limitations issues, it usually stems from the time that the action took place.
Mm-hmm.
However, this doesn't necessarily apply to every issue. Say, for instance, that you were a fiduciary, which by that I mean you had a legal obligation and a relationship to another individual. And say that having that legal obligation to either care for someone or act responsibly on their behalf, you screw up big. They don't have the statute of limitations run until that person that's been injured is actually made aware of the issue.
So what does it mean for statute of limitations to run? What does that mean?
I'm sorry, what did you say?
So what does it mean if the statute of limitations runs? You said it doesn't start to run. What does that mean?
So in this case, that means that the imaginary clock hasn't really counted down. In the case that Ben said, 10 years, as soon as that action takes place, the 10 years could start counting down. In the situation I just gave you, as soon as the person that's been hurt finds out about it and can actually bring that issue to somebody, that's when it starts counting down. It's really dependent on your jurisdiction,
right,
what state you live in, and really what the rules say and the precedent set in those different states and jurisdictions.
Yeah, so essentially, regardless of when they take that data, there's essentially no law that stops them from using it any time down the line. Is that what you're saying?
Pretty much. It's property of the state at that point, at least in the majority. They can use it as if it was their own, but we all know that they're not really doing it for the benefit of anyone. It's usually to try to surprise someone years later when they should have had a real right in their property to get rid of it if they wanted. Maybe they wanted to go clean, whatever it might have been.
All right. Yeah. So this is all really interesting, and I think this kind of ties in with some of what we were talking about with other disadvantages that people experience in the law because of their income. Right now, so just to wrap this up, and I don't think there's a ton of happy endings to this.
Unfortunately.
Yeah, I don't think there's
Yeah.
I don't think there's a lot of hope we can give kind of at the end of this. So, are there any other thoughts about kind of your Fourth Amendment rights and data and Fourth Amendment rights and computers that you want to give like some closing thoughts on that, or how it could be protected if you have some ideas about how that might work, just to kind of tie off this conversation before we wrap up.
Sure. So just as a practical matter, if you ever have a question of like police officers coming up without a warrant, or you have someone maybe pulling you over and you're nervous, just remember, polite but firm. And always let them know that if you don't feel comfortable, let them know that you do not consent to being pulled over, and that you want to know if you're free to go, or if you're able to leave, or if you just are being held against your will, because these specific terms have big implications. If an officer is telling you that you aren't free to go, and
your next question should always be, am I under arrest?
Yes.
And if it is, the next thing you should say is, I do not wish to speak until I have an attorney.
Yes. And unfortunately, I'm trying not to make it too many cans of worms at one step.
Yeah.
Because there are times when silence is actually used against a person. There was an issue.
But in many cases, silence is your friend. Yeah. So
exactly.
Let's not go too far down the road. So you're good. So closing thoughts on the data issue. Can you protect yourself against it? Should you give over your computer to the cops? Things like that.
Yeah. Effectively, if you know that they don't have a warrant, make them get a warrant. They have to for a reason. It's in the Constitution for a reason. They have to show that there are valid reasons to take a person's items or their person. And if you do consent, understand that your need to take back that consent has to be quick. You're on a very short time frame. So protect yourself, be smart, and know your rights.
Great. Well, this was a great conversation. I really appreciate you coming on and talking about these things. And if there are any further issues any questions people have about these issues, I will certainly forward them on to you. Thanks so much for coming on the show, man. I really appreciate it.
My pleasure, buddy. Anytime.